Can y'all hear me?
We can. Yesenia is just going to get started right away.
Perfect. Thank you. I'm so sorry.
No worries.
Hi. Hello, I'm Yesenia Compian. I'm with Northeast. I'm one of the 7 transition teachers that we have here. And I just wanted to say thank you for coming. And we have partnered up with a consolidated planning group. And I will turn this over to Ms. Schaberg.
Thanks so much for having us. It's certainly a pleasure to be back with you today. I'm just going to give a few little housekeeping items. So today's webinar is being recorded, and you are going to get a copy of today's slides as well as the recording. You'll get an email this afternoon later on with that information. So you don't have to take notes of every single thing he says because you will get a copy of the slides. So we are in webinar mode today, and that means that we basically can't see you or hear you, but we do know you're there, and we're glad you're here. So whatever your journey is, today, we always talk about some special needs planning topic, but today we are talking as it relates to divorce and special needs. So whether you're in the middle of it, you're post-divorce, you're thinking of divorce, there's any number of combinations that could be, in your wheelhouse today. We're glad you're here, and this is really a meeting that's just really designed to be informational and give you the tools and the resources that you need to be able to make those good decisions as you're kind of embarking on this journey. So I'm Allison Schaberg, Consolidated Planning Group. We are a holistic special needs financial planning firm. We are not attorneys. So the interesting thing is a lot of times when it comes to special needs planning, people call us and they say, hey, I need a special needs trust or I need guardianship. We work very closely with attorneys all across the state that help with those things. But in a nutshell, what I would like to say is that they're the paper. They're the legal documents. They're the paper. Those are things that you have to have, and we're the money, we're the funding, we're the money in the right buckets when we start talking about, planning for Social Security, lifetime protection plans, ABLE accounts, those types of things. Those are the things that we help you with. So sometimes there's some confusion on that, and I always like to bring that up. But it is certainly my pleasure to be back here with Mike Day today, and he is going to be talking all about this divorce topic and planning for our special needs loved ones. And he's going to talk to us about what every parent needs to know. So what I'd like to ask you guys to do today is as we're going through this presentation, if you're planning your lunch, we're going from 12 to 1. We will be finished by 1. But if you have questions, put those questions in the chat box, and we're going to get to just as many of those as possible that we can today. Mike, I'm going to turn it over to you. Thanks for being with us.
Oh, thank you so much for having me, Allison, and thank you so much to Northeast ISD. It's a real honor to speak to y'all. It's a wonderful school district, and it's really my honor. And I know that y'all are in San Antonio, but I would be remiss if I didn't say go Stros. It was a momentous World Series win this past weekend, and if you don't like the Astros, my apologies. But
Right.
let's go to the first slide, I guess, Allison. Before we start talking about how special needs divorces are different from divorces with children who do not have special needs or children or no children at all, let's talk about how they're the same. Because one of the things that I've really discovered in my practice is that there's a lot of underlying trauma with most divorces, whether it's betrayal trauma or trauma from some other sort of circumstance. But invariably, there's some degree of trauma. And that's why you need to know a couple of things. The first thing you need to know is that you're not alone. Okay. Lots of people are going through this, have gone through this situation. Now, that doesn't necessarily make it any easier or minimize any circumstance anybody else might be in. But just know that this is an unfortunate reality that a lot of people have had to contend with. The second thing is that you need to engage in self-compassion and self-care. And let's talk about really what that means. That means making sure that you have your support group together, whether it's friends or family. A lot of times, if someone doesn't already have a mental health provider, I explore whether or not somebody should want to meet with a therapist, because life is hard and going through divorce is also very, very hard. And you put those two things together and it can be quite difficult. And so that's one of the things that you just need to know, is that you need to put together a good team. And then lastly, when children are involved, is that you just always want to put the kids first and work backwards from that. And sometimes people can't agree on what that means. And that's unfortunately where the legal system really starts to get involved. But if there is a general consensus as to what is in the children's best interest, then sometimes it's really a matter of the logistics or the tactics on how to accomplish that. And so once you've figured out what you think is in your child or your children's best interest and work backwards from that, that's what I tell anybody going through a divorce. That is the first thing that they need to do. So I talked about engaging the self-care team, the support group, the support network, potentially a mental health provider. But in terms of the actual legal and X's and O's, when there's a divorce involving a child with special needs, there are 3 other experts that you should really think about having involved in your team. The first is a special needs planning attorney. That is not what I do. That is not what virtually any family law attorney in the state of Texas does. And quite frankly, a lot of estate planning attorneys, even the very good ones, unless they have a real emphasis in their practice on special needs, you probably want to make sure that whatever special needs planning attorney you have on your team has a lot of experience with this, with drafting first party trusts, with drafting third party trusts, if there are going to be multiple trusts, because sometimes there are multiple trusts. This is subject to all these sort of complex federal regulations that change fairly frequently. And so you need someone in particular in drafting the first party trust. I mean, because that's the money that child support gets paid into. And so if that's not done properly, the child's benefits could be lost or potentially lost, or certainly made a lot harder to maintain or obtain. Allison, I don't know if you want to have any
Yeah, I want to
perspective.
just back up a little bit, because there is some confusion on this, clearly. Okay, so certainly, we have referrals for attorneys that are specifically nuanced in special needs, that work on those special needs trusts, like Mike is talking about, first party, third party, guardianship, things like that. But I think sometimes there is confusion of, the type of attorney that you are. So you really focus on divorce and special needs divorce. But this is where, when you're saying that make sure that you have a team, all of the people of the team really do come together, and that attorney that is nuanced specifically in special needs. And again, we have referrals all over the state for ones that we know are good. We know they do a great job. We know that their prices are fair, those types of things. So if you need a referral, we can help you with that. But the key here is it is kind of a team, because it's not all one big family. The special needs advisor, the special needs planning attorney, the special needs divorce attorney, they're not ever one person, ever. So I'm so glad that you brought that up. It's really important to understand that.
And in fact, if someone tells you that they can do all of that, then you'd be well advised to get a second opinion, honestly, because most of the lawyers that draft these types of trusts, they might occasionally do stuff in family court, but certainly nothing that's ever contested, right? I mean, most as a general proposition, any estate planning lawyer, I won't say any, most estate planning lawyers, they don't want to come anywhere near a courthouse involving family law matters. So they just don't. That's just not what they do. And so, but the other components of the team, special needs financial advisor, because the lawyers can't tell you how to manage the money. The lawyers can't tell you, what investments to make, that sort of thing. That's really where somebody like Allison is involved. And then lastly, a medical team if necessary, and the medical team really becomes involved in one of two situations. One, the parents do not agree that the child is disabled, right? And so sometimes there is a rigorous debate in the courts where people have to go litigate whether or not their child is disabled. Because, and we'll get to this later on in the slides, there are a whole lot of collateral consequences that will arise if there is a disability finding in a divorce decree. But the second thing is that sometimes, and so you would need that medical expert to opine as to the ultimate issue of whether or not the child is disabled. And that's extraordinarily rare. Most of the time, if you have a child with special needs, the parents have consensus. But it's been my experience, in particular with children on the spectrum who are higher functioning, that you're going to have some pushback from the other parent who is the one who's going to have to pay for child support, right? And so sometimes you are going to have to litigate whether or not the child is actually disabled. But sometimes it's really more a question of the extent of the disability or what sorts of care should happen. And sometimes, that gets resolved in probate court, and sometimes it gets resolved in family court. Frankly, it could get resolved in either place. But sometimes, and you'll see this with one parent, sometimes they'll want to do more experimental treatments, more experimental care for their child. Maybe they'll think that it's more dietary related. And so then there will be pushback from the other parent about whether or not that diet is appropriate or that treatment is appropriate. Because, if the parents don't agree, somebody's got to settle that dispute, right? Whether it's the court or somebody else, but someone's going to have to resolve that. And that's why a medical team, it would be necessary in those sorts of situations.
And so someone said, well, this sounds expensive. And obviously, anytime if there's disagreements and we're not agreeing, obviously those types of things do get more expensive quickly. But a couple of things that I just wanted to mention is, there are a lot of divorce attorneys out there, and not very many of them are nuanced and special needs. So what if you've hired one? So we're not here to say you should ball that up and throw it away and forget it and hire somebody nuanced and special needs. People like Mike can consult with your attorney. If you've already hired a divorce attorney that doesn't have any background in special needs, people like Mike and people that are nuanced and special needs divorce can consult with your attorney. If you haven't hired an attorney yet, it is wise to hire one that has some background when it comes to special needs and what needs to happen in your documents, because those steps that you take now and kind of on the front end, it's a lot easier to do it on the front end than it is to do it on the back end when it's not unfixable, but it is easier to get things set up on the front end. So I just wanted to mention that, because I think everybody always think, I already hired somebody, I already paid, a huge deposit or whatever. Now what am I supposed to do? They feel nervous about that. But Mike, you do consulting with other attorneys as well. Is that correct?
That is correct. Yeah. And there are different arrangements that can be made, not just with me, but with anybody who does a lot of special needs, family law related work. But the only other thing I'll say, and this is true of divorces involving children with special needs and divorces that do not, is that when people say this is expensive, invariably it probably is, but also you just have to look at the amount in controversy or what there is to be gained or lost, right? Because that will really kind of put things in perspective for you from a business judgment sort of perspective, right? But yeah, we can go on to the next slide. So this is really the heart of it, right? This is what it takes to be determined to be an adult disabled child under the Texas Family Code, okay? And everyone can read the slide, but I just want to emphasize the fact that it's right? So the child requires substantial care because of a disability, and also you also have to show that that ability exists or the cause of the disability is known to exist on or before the 18th birthday of the child. And depending upon what governmental benefits the child is receiving, sometimes you really have to get adjudications made before the child is 18. Sometimes you don't. The child's is beyond the age of 18 and there aren't benefits being paid, then there should likely be no prejudice from getting a finding then. But this is very important because, and another thing too, is that this does not mean that the child doesn't have capacity to make their own decisions necessarily, right? I mean, the child It could be purely a physical disability. Sometimes you have, normally there's sort of an intertwining of both. It's not one or the other, but I have seen situations, and it's interesting because the family code, normally if a child turns 18, then you don't have any sort of possession and access issues to determine. What does that mean? That means, whose weekend is it, that sort of thing. But once a disabled child turns 18, the court can retain jurisdiction to entertain possession and access issues, as well as issues regarding the rights and duties of the parents. There's a legitimate debate to be had about the extent of the court's ability to decide rights and duties. Some people will say that it's just child support. Other people will say that it can be read more broadly than that. And I won't really get into that debate. That's pretty far into the weeds. But at the end of the day, just know that this disability finding has power. All right. It's what's going to help a child get benefits. It's going to require child support to get paid into a trust, not to lose those benefits potentially. It's going to allow the family court, which is, good or bad or indifferent, one of the most intrusive institutions in the legal system, right? I mean, there aren't many courts that have as much power as a family court, right? I mean, they can ask for people to be drug tested on a moment's notice. They can tell you what to do with your children. They can literally order money be withheld from your paycheck. I mean, courts, generally speaking, aren't in the business of doing that. And so, but this is the statutory finding that you're going to need if you're going to want to have child support paid beyond the age of 18 and graduating from high school, or if you're going to want to have the court to decide possession and access issues.
So let's just talk about that really quick. And I know we've got several slides to get through, but the key thing, and I know that you're probably going to talk about this, but one of the key things from a financial planning perspective that we see mistakes in this is where they go ahead and they get the child support going to continue post age 18, but it was never ordered to go to a first party special needs trust. So the bottom line is, and the main thing you guys need to know is that if the child support is going to continue post age 18, it does need to go to a first party special needs trust, or it will be counted against the child for SSI and Medicaid purposes. So it's really, really important to have that language in there so it can be redirected to a first party special needs trust, either in the beginning or at that time as they're approaching age 18. But it can and will be the reason why there's either a reduction or no SSI and Medicaid awarded. So this is a very, very common thing that we see from divorce attorneys that don't have any background in special needs. They have no reason to understand SSI and Medicaid because that's not what they do. So I just wanted to be clear on that.
And so the next factor is sometimes you have children who clearly have special needs, but they don't necessarily, they're too young to meet this standard. It's too soon to tell whether or not they're going to be incapable of care. And so in the meantime, what you can do potentially is use the child's medical issues as a way to get above guideline child support. And that's very important because in Texas, you look to the net resources, which is effectively the first $9,200 after taxes. And then if there one child involved, it's 20%, two children, 25%, so on and so forth. But if you need more than that in the meantime, it's not like, well, I can't get the disability finding, so I'm just not going to mess with it. I mean, sometimes it can be used for other things as well. And I think, Allison, we have some questions. I don't know if now would be a good time to address some of these questions or not.
Yes, some of them I'm answering, and here's one. If child support continues after 18 per divorce decree, can you get it switched at a later time to a special needs trust once one is set up? Yes,
you can. You would need to talk to an estate planning lawyer about what consequences that may or may not have for benefits and what have you. But strictly from a family law perspective, you can, If the child support obligation is required to be paid after 18, and if there's a disability finding, absolutely.
And then another question sorry, it jumped on me. Let's see, self-support. How broad is that definition? Does it apply to the ability of the child to financially support him or herself?
That's a great question. I'm going to give you a typical lawyer answer. It just depends. There have been cases there's one case in particular that almost went up to the Texas Supreme Court, where the child had been found to be disabled and had money to be ordered to be paid into a trust. And then several years later, the parent who was responsible for paying for that child support said, well, wait a second, this child's in college and is in a dorm and is possibly going to go to grad school. I really don't feel like I need to be paying child support if my child's, able to attend college. Well, ultimately, the trial court disagreed, and the Court of Appeals affirmed the trial court. And that's the thing about family law, is that it's extraordinarily difficult to get something reversed on appeal. And so you winning or losing in the trial court is about 95% of the battle. And so, but it's interesting because that case went up from the Intermediate Court of Appeals, and the child support obligor tried to appeal it all the way to the Texas Supreme Court. And so she's not on the bench anymore, but there was a woman, Supreme Court Justice named Eva Guzman, who had been a family court judge in Harris County before ultimately going up to the Texas Supreme Court. And so she wrote, not an opinion, but just sort of a memo, if you will, basically saying, well, I don't disagree with the decision not to revisit this case, but this adult disabled child statute is complicated, and there are lots of unresolved questions. Like, if a child's disabled, can they found to be no longer disabled anymore? Or is a court bound by that prior finding? And even if a court cannot revisit that issue, what latitude does the trial court have to give the person responsible for paying child support relief? And at the end of the day, there are a lot of questions that are kind of unresolved. But yeah.
Well, let me burn through a few other questions.
And there are cases where children have jobs, and that's been found to be evidence not of being a disability. In that case I had mentioned where the child was in college, there was a lot of evidence where the mother was still highly involved in the child's life and would basically take care of the child a lot of the time in the dorm room. And so, yeah, the child was living in a dorm, but it wasn't like, immediately.
A lot of disabled kids
when you hear
do
that,
go to
you
college.
think, okay, well, this is a child who's going to be extremely independent. And some of the facts in that case did not support that proposition.
For sure. All right. So let's say, for instance, that you already had a divorce and you already had child support. Child support's slated to stop at 18, but the child is disabled and it wasn't taken into consideration for child support. Do you recommend that they go back and have that revisited? And then how often in the state of Texas can you have child support revisited?
Well, so you can have child support revisited anytime there's a quote unquote material and substantial change in the circumstance of the child or the obligor or the parents effectively. So that's really, now, if you go to court a lot and you're always saying there's a material and substantial change, you're going to get the judge is going to kind of be skeptical, right? If someone's always going to the courthouse saying that something has changed or something is different. But generally speaking, in cases involving children who do not have special needs, I mean, people say every 3 years, unless there's a huge swing in income up or down.
Okay. And another question is, if we have adult kids that are disabled, 18 and 21, if they receive SSI, will that play a part in the amount of the child support awarded? Would they reduce it for that?
I'm sorry, say that again, Allison.
So basically, if we've got adult kids, 18 and 21, that are getting SSI, would that play a part in the amount that the child support that would be awarded in that example? I guess furthermore, if they're already 18 and 21 and she's not getting child support post age 18, is that even a factor?
Well, I think it's an open question if the child is over the age of 18 and the divorce hadn't been finalized or even initiated yet, right? Because I think there's a strong argument to be made that the payment of child support in that sort of situation is not right. What the important thing is whether or not the disability or the causes of the disability was known before the child turned 18, not necessarily when you got child support before or after 18. In terms of other
I just need to reiterate there too, again, so I think it's a twofold question of like, is the judge going to award less child support if they're getting SSI? And that's your department. But when it comes to SSI being reduced for child support, SSI will definitely be reduced for child support if that child support is not going to a first party special needs trust. So that, because there's some confusion in the chat box, and those are two different separate topics.
Right. Yeah. And so in terms of how the judge is going to treat SSI income, I mean, technically they're allowed to consider all financial resources. It'll also be a product of whether or not the child support. Okay, so there was a case that came out in Houston Court of Appeals in 2013, 2014. And that was the case that was one of the first cases to really construe this statute. And it said that you do not just look to the special needs considerations in the child support statute, that you have to look to all the child support factors, right? So, because there are basically two parts to this inquiry. One is the obligor maxing out or not? Because if they're not maxing out, then there are about 14 different factors to look at if you're going to ask someone to pay above guideline child support, right? But if someone is making above the $9,200 a month after taxes, then they're maxed out. And so then that becomes a question as to what are the child's quote unquote proven needs, right? And then you apportion between the two parents those needs, right? And I think a lot of judges, if they're going to be reluctant to make someone pay a large child support sum, or really any, although people will be expected to pay something in child support, but if a lot of this is being paid for through benefits or through other sources of income that belong to the child, I think the court can, or more importantly, as a practical matter, will just consider that. I just think they will.
Okay. What about in an example where somebody had child support, but their attorney specifically mentioned for it to just go ahead and stop at age 18, but the ex still pays on the side, but it's not legally bound? It's going directly to the mom, not the child. Is she still risking not qualifying for SSI and Medicaid if the actual divorce decree doesn't show that the payment was going past that time?
That's not exactly my area of law. I don't really do the benefits, qualifying for benefits, but I would be surprised if that was not problematic.
What I would say, and we are nationally certified as Social Security advisors, what I would say is if it's something that they found out about, it would become problematic. Once the child is 18, it's based off of their finances, their income, their assets, not yours. But if it came to blows ever, or it came up somehow and they knew about it, I do believe it would become problematic as well. Okay. Got a few other. I think we're going to move on for right now. Okay.
Okay. Okay. Cutting edge issues, Quadros and Secure Act. Okay. So the Secure Act is a relatively recent form of federal legislation. And one of the really interesting things that it does is that it allows a special needs trust to be funded by a retirement account, 401k, that sort of thing. And then that's really important. That's really powerful, because sometimes, especially if it's a divorce where maybe it's amicable, or maybe it's just, as I like to call it, amicable enough, right? Where the parties can get along enough to kind of enter into sort of a consensus type framework for how the disabled child is going to be cared for. You can have some, what I call estate planning by other means, right? And so, because one of the things that the family court can accomplish for people is they can accomplish something called a qualified domestic relations order, which is a way under ERISA to divide a party's retirement, okay? And so through that, you can get a court order that requires a trust to be established, that requires a trust to be funded, and as well as specifically laying out how that trust is to be funded. So for example, you theoretically now with the Secure Act could have a court order where the last bit of the 401k, right? Or I won't say last bit, but a chunk of the 401k could be used to actually fund a special needs trust, where you didn't necessarily have that before. And I'll also say that there was a very problematic Texas Supreme Court case that came out, I want to say in 2018, where it really kind of removed the ability to use quadros to support to try to get a child support arrearage, right? Because that was something that people were doing outside of Texas, across America, is that they were, because someone would not pay child support, but they would continue to fund their 401k at their job. And so there was some money there to basically be had to support a past due child support obligation. And there's also that ability now in Texas. It's very specifically made now. Okay, how is the support determined? Okay, well, let's look at the very specific factors. Next slide, please. So any existing or future needs of the adult child. Now, this is very powerful, right? And this is where sometimes medical experts get involved, is figuring out exactly what are the future needs of the child. Is the child, like, for example, and I don't mean to paint with too broad of a brush here, but let's say it's the mom who's historically been taking care of the child with special needs. Well, eventually that mother's not going to be able to do that forever, right? I mean, maybe she'll have her own medical issues that she'll need to attend to, and then that child will need to have some other sort of caretaker. And so the ability to try to forecast for that possibility, potentially anyways, under the statute, is very powerful. And I've seen it to great effect, where you're trying to get a better settlement than maybe you could otherwise. Now, this goes back to also the Houston case I had mentioned. It's called NRA JMW, where you look at these factors, but you don't look at these factors in a vacuum, right? You also have to look to the general child support statute. And so the big thing there is whether or not the child support obligor is making above the max or above the cap or not. But these are the factors. So, and someone asked earlier, well, what if the child's receiving SSI? Is the court going to do that? I think this statute arguably gives the court the ability to at least consider it. And I'll also say that, that question presumes that the SSI is for the child. If there is a parent who is receiving Social Security age-old benefits, or receiving their own type of disability benefits, that is part of the general child support statutory framework, but that will also come into bear, because I've seen cases where people have had these types of, where an obligor has had these types of benefits, and then they get a credit against what would have been their child support obligation. I'm just kind of looking at the chat box. Next slide, please, Allison. So this comes to the question, and you'll see lawyers argue about this sometimes, which court should be making some of these decisions. Harris County, which is obviously different from Bear County, they have their own family courts and their own probate courts. And so it's been my experience that the probate judges want to have, they're not in the business of deciding family law disputes. So if they don't necessarily have to do that, then maybe they won't. And they'll be happy to defer to a court that listens to child support disputes and possession and access disputes every day, right? But what this is important is that, and this is something frankly, a lot of family law attorneys don't fully appreciate, is that even if you have a child with special needs, even though the child is 18 and graduated from high school or not, it doesn't matter, because the court can still decide possession and access issues. Who gets what weekends, holidays, that sort of thing. And it's only when both parties have sort of invoked the jurisdiction, or at least one party's invoked the jurisdiction of the probate court, and one party wants to have everything heard in the family court, that things get more complicated. And again, it's been my experience that probate judges want to hear more stereotypical probate type disputes. And so the one thing that they must hear are guardianships, right? And then the court, if people can't get along, the parents can't agree, there's almost certainly not going to be co-guardians, right? There's only going to be one guardian appointed, which is very different from the practice of family law, which says we're going to try and get both parents involved to the extent that we can. There might be one parent that ultimately gets the ability to make the decisions if there's a disagreement, but we want to incentivize both parents being involved. Next slide, please, Allison.
We have one other question. We have several questions. I'm
Okay,
monitoring
let's talk about the
as best
questions.
as I can, but I wanted to get through the slides as well today. Someone asked, and she was talking about the rule and the statute apply. Does it apply nationwide? State that all 18-year-olds and above, even if they are disabled, doesn't qualify for child support as they are coined independent after that? Or is it state specific?
Two things. One, it's very much state specific in terms of child support. That's always decided as a matter of state law. Now, some of these things we're talking about in terms of the Secure Act and having a retirement fund, a special needs trust, that's federal law. So that's the law throughout the country. And so really what you're looking at is not only the state that, not only is it a matter of state law, but it's the matter of the first state to hear the issue. For example, let's say you have parents who live in different states, right? Well, in that situation, what normally happens is you have a law called UIFSA, which is the Uniform Interstate Family Support Act. And that says that the child support is decided where the obligor is, right? So the person who's going to be paying the child support. And in that situation, the law of that forum attaches. So let's say you're in California and the obligor lives in California and the obligee lives somewhere else. And then there's a California child support judgment, right? And then the people move back somewhere else. There's a very, very good argument to be had that, well, I won't say California law applies, but it potentially it does. And certainly as long as that obligor lives in California, it's not going to matter what Texas law is. It's one of the, because generally speaking, jurisdiction follows where the child lives, but child support is probably the most conspicuous exception to that.
Okay. So then there's a question, how does the money flow for a first party trust? Can the funds just flow through like the original child support, or does it have to go to a specific agreed upon needs for every expense for care? So what I'm going to tell you is we have an entire webinar dedicated to first party and third party special needs trust, what you can and can't pay for out of those trusts. There is a 1/3 reduction for paying for food and shelter out of a special needs trust, a 1/3 reduction to SSI. So you are going to want to be aware of that, but it's usually, you know, care for, I mean, and the list is very, very broad. We have a long list of things that a special needs trust can pay for the benefit of said child. I mean, and it could be such things as entertainment, it could be a vacation, it could be a car, assistive technology, of course, all the things you already know, therapy appointments, co-pays, medicine, so many things. It's very, very broad what you can pay for out of a special needs trust. And then the other thing is I think the key, the biggest things, I know we've had a lot of talk, the talk is child support. We've talked about kind of, that they could get an above amount of the guideline of child support in the example that the child's care needs are greater, et cetera. But the biggest thing, I think that the biggest thing, if you're starting this process, we've had people in the chat box that say they're starting the process, some have completed the process or whatever, is that if you're at the beginning of the process, working with the right people on the team, like Mike was talking about in the beginning, getting that first party special needs trust set up to designate future child support, having those intentional conversations about child support post age 18 and those types of things. Those are the biggest key things that you need to be thinking about, and just jotting that note down of having those conversations with your professional, with your team, with your divorce attorney. If your divorce attorney is not nuanced in special needs, pulling someone in like Mike or someone who is, so he can consult them on kind of what are the steps to do that. Those are the biggest things. And I think that that's probably going to answer most of those questions as it relates to those things. And the whole reason we want that first party special needs trust for child support is simply to either maintain or keep your child eligible for SSI and Medicaid in the future. And to take that one step further, all of the waivers in the state of Texas are Medicaid waivers. So even if you yourself don't really even care about the money that comes along with SSI, saying it's not very much, we do want our kids to stay Medicaid qualified, so that way those interest lists in the future and the waivers, then they can qualify for those waivers. So it is a full circle thing. Guys, we've got entire webinars on every single one of these topics: SSI, special needs trust, guardianship, waivers, you name it, it's out there. So I just want you to know that that's on our YouTube channel. Our YouTube channel's in the chat box, and you guys can subscribe to that for free. I just want to put that out there. Mike, do you want to kind of add to that?
No, I would just say that it's imperative that if you have a first party trust, that you have the name of that trust clearly identified in the divorce decree, and that the child support payments go there. Because I have seen cases where the child support obligor will be like, well, you know what, that's fine. The child's disabled. I'll pay child support, but I want to pay child support into the trust that I control, right? And so I want it paid into the special needs trust for child XYZ. And the parent who is the obligee, who's taking care of the child's like, well, wait a second. I don't want to have to come ask money for permission from you to spend money on behalf of the child. That's why we got divorced 10 years ago. I don't want to have to do that. And that's a real concern, right? And the few times I've seen people take that position in court, it's never been very persuasive, but people do that, and they do that. And I'll go back to the original slide, right, about, comparing divorces with children who have special needs with divorces that don't have those issues, is that you still have issues of control. Sometimes people still try to control the other spouse, ex-spouse, well after the divorce is over with. And it's typically very unfortunate. It's typically not well-intentioned, but that is the reality. And, so you want to be very careful that you just don't say, well, it's going to get paid into the special needs trust and the divorce decree. You need to really specify the trust by name. And I would also encourage people to have the trust all drafted. Lawyers can disagree amongst themselves whether or not the trust agreement needs to be attached to the divorce decree or not, but you need to have some sort of paper trail that if it's an agreed divorce decree, that this is how the trust is going to be worded. because again, going to the control issue, even if someone says, look, I'm fine with you controlling the trust, I just want it on my terms. I want the trust to read XYZ. What's wrong with that? And it's still the same thing, just maybe a slightly less asinine, but still pretty bad.
I want to comment on that, and thank you for saying that. That is very, very important, and that we've definitely seen that come up. Another thing is that there is a requirement. So here's what I'm going to say: your situation is specialized. Work with specialists, because what I have seen is they just have it directed to a trust, not a special needs trust. It has to be a special needs trust. It has to be a first party special needs trust, and it has to have a Medicaid payback language in it to be construed as a bona fide trust in the eyes of the Social Security Administration. And what I have seen is I've seen some of these first party special needs trusts drafted without the Medicaid payback language in it, which failed to qualify as a trust in the eyes of Social Security. So just be careful. Again, we're happy to make referrals. We've got people all across the state that are nuanced. This is what they do. This is not a do-it-yourself project. This is not, I'm going to hire my neighbor because he's free and he does real estate, but he can dabble in this. We really, really recommend, it's so important that you get this right. And so I just wanted to mention that because we've definitely seen some messes, I would call it, with that.
Yes, yeah, and I would completely concur with that. Okay, the next slide. So normally what happens when people reach a family law agreement is that it's kind of a back of the envelope type thing, right? You go to mediation and you're going to agree on XYZ bullet points. And then you're going to have this document called the Family Law Practice Manual, which is sort of the best practice for family law attorneys in the state of Texas. And we're going to use the enabling language found in the Family Law Practice Manual. And that's what's going to govern. And if we have a dispute about, because these back of the envelope type deals will get brought in and they'll be turned into, 40-page divorce decrees that lay out everything very specifically, which is what you need, generally speaking. But the problem with using the Family Law Practice Manual is that it's an incredible document. The folks who put it together do an incredible service to the family bar and by extension, the family bar's clients. However, there are some provisions in there that if you just kind of default to them could be problematic. The first two that come to mind are the obligations to use providers within network. Sometimes that's not a good idea for a child with special needs. And if you are the parent who's primarily taking care of the child and you are under a family law order that was drafted with the Family Law Practice Manual in mind, you're typically going to be required to use preferred providers. And if you opt out of that, in particular, if the other side hasn't agreed to it, you're 100% on the hook for those expenses. And that's not neither the primary caretaker's best interest nor the child's best interest. And then sometimes there's a very limited definition of medical care, right? So go back to the dietary considerations, for example. If you, even if you and the other parent are in agreement that the dietary restrictions are a good way to help your child, in order to ensure that there's some sort of understanding as to how that gets paid for, because some of this stuff is not cheap at all, is that you want to address that. And if it comes up as an issue of, well, I need this for the medical care, but it's explicitly not included in the definition of medical care, there's going to be potentially some problems there. So that's just two examples, and again, this is why even folks who have a lawyer already, but they that lawyer might need to consult with somebody to just know that some of the stuff in the divorce decree needs to be drafted correctly, even if the deal's been made.
So somebody said if the divorce decree has it going to the special needs trust, but there is no payback to Medicaid, that doesn't have to be in the divorce decree, the payback to Medicaid. That has to be in that first party special needs trust. That's the first party special needs trust language. But let's just say, for example, that this person has a divorce and the child support's going to the first party special needs trust, and she's looked at her special needs trust and there is no Medicaid payback, can you amend the divorce decree, or do you need to, or do you just need to amend the first party special needs trust and get it corrected?
Great question. Very nuanced question. I will say this much, a couple of things. One, you would have to look to see how the trust is identified in the divorce decree. Because, for example, it might be a better practice to say such and such trust, and you know, do you want to include any sort of modified provisions of the trust? Because if my concern is that if you modify the trust without apprising the family court of that modification, that could be complicated on the child support thing, you know, on the child support side of things. But with respect to Medicaid payback, again, I don't necessarily practice that area of law, but you would need to do, I mean, there are very clearly laid out best practices on the
But I
Medicaid
will
payback. And I will
say
say
that if
this
it's
much about
in
the
that
trust,
first party trust,
and this goes
it-
back to whether or not I'm sorry, Allison, I didn't mean to speak over you.
I was going to say, I just wanted to say that for sure that if the first party trust has the Medicaid payback language, it doesn't matter if the divorce decree does. It's for the first party special needs trust. That's required by the Social Security Administration, and they definitely have a POMS on that. They have, you know, they have a kind of the rules on that. So that's basically, and so I think that is probably way too nuanced for this webinar. Like, you know, you'd have to go deeper into exactly what's going on with the document. But the Medicaid payback is required by the Social Security Administration. And someone said, what is a Medicaid payback? And basically a Medicaid payback is upon the individual with the disability's death, there is a calculation, and it is clear as mud. You can Google it on, you know, on the Social Security Administration website. They have, you know, a calculator. They have all kinds of formulas that they calculate this, but basically they look into what did we pay on behalf for this individual? What do they have in their name? And there's a payback. There's a calculation for the payback of paying the state back for what they paid for your kid. And first party special needs trusts do have a Medicaid payback.
The one other thing I'll add just real quickly to that, Allison, is that depending upon how the trust is identified in that particular divorce decree, like for example, if they don't make any reference to the modification of the trust, and you just go ahead and you want to modify the trust to include the Medicaid payback, there are potentially some procedural shortcuts that someone could take. They could just potentially file a Rule 11 agreement with the court. I don't know that you would need a brand new order, but a lot of this stems from whether or not the other side is going to agree. I mean, that's the thing about this. I mean, when people are in agreement, it's a relatively straightforward process most of the time, right? It is when people, and when I say people, I mean primarily the parents, disagree is when things get complicated. And I will say that if a parent says, you know what, I'm not going to agree to this trust modification, then it comes down to what does the underlying trust agreement says. And I will say this, and I had this situation come up years and years ago, where the other side was very insistent that they wanted the trust attached as an exhibit to the divorce decree. Because what they did not want to have happen was what the law calls an agreement to agree, which is the idea that you guys kind of have a general understanding, but it's not really enforceable, right? And so, and that, because this lawyer, who was probably 70 something years old when he and I entered into that settlement, he had a trust effectively set aside because there was a profound disagreement later on down the road about the trust provisions regarding the child. And the court found that there was no agreement to agree. And the only other time that I've seen that happen is when someone had an agreement to pay for college, right? Because normally family court doesn't require, I mean, they can't, right? They generally cannot do that, but parties can agree, we'll have a contractual obligation to pay college tuition, but they did not have a cutoff time, right? And so when the one parent said, you know what, I don't agree with whatever was going on, I'm going to not pay into this college fund anymore. Well, then the other parent brought a breach of contract lawsuit, and the family court judge said, I don't think this contract's enforceable because it's for an indefinite duration, and you can't have that. You have to have a specific period. And so now whenever I draft these contracts to pay for college tuition, it's always when the kid's around 25 or so, but you could do it anytime, I suppose, any reasonable time, but you have to have that contractual obligation terminate.
So, Mike, I know we're running out of time, and so I've got one question that I want to hit on, and then I want to hit on some key things that from our practice that we've seen that are helpful when you're thinking about this journey that you're on. But just talk to us when parents don't agree, especially like when we're thinking of high functioning autism or other, disabilities like that. What is out there to help these kids in this situation? Is it neuropsych testing? Is it doctor's records? Is it petitions for guardianship and signing off? How does somebody, when they've got somebody that is denying the child has a disability, how do you help them in that example?
Well, I think it's two things. One, if the child is younger than 18, then there's not going to be a guardianship. If the child's already
Sure.
18, look to see what happened in guardianship court, because if people were getting along then and then they entered into certain findings, right, because they both wanted to be co-guardians because they both wanted to have control or whatever, maybe that party that's now wanting to basically welch on the supporting the child is in a real pickle because they're judicially stopped or bound by the position they took in different litigation. If the child is younger than 17, or excuse me, younger than 18, but it's getting close, right? Or maybe the child turned 18 and these folks, just a divorce wasn't on anybody's radar at that point in time, right? I mean, there's an argument to be made that you can come back after the child's 18. It's not definitive, but there is an argument to be made. Yeah, you get medical experts. And the one thing I will say is that you do not just go get an evaluation done, from some psychologist for $600 or whatever. No. You have to be completely upfront with that medical professional, or your lawyer does, and says, look, I need you to opine as to the ultimate question as to whether or not this child is going to meet the adult disabled child statute. Because here's the reality. A lot of folks who practice a lot in the family law arena, they're custody evaluators. They're not necessarily trained or competent. I mean, some of them could be, right? But a lot of them, they're just doing custody evaluations that are very different from what you're looking at here in terms of opining as to the issue of a disability. And so the people that normally do custody evaluations and other sort of family court type work, they don't want to get involved because it's not their expertise. On the other side, the medical providers that work a lot in the special needs area, they're like, well, wait a second. I don't have the requisite qualifications to offer a custody evaluation, right? Because the family code is very specific about the qualifications that an evaluator has to have. And so how I've threaded that needle is I've said to the medical expert, I'm not asking you to do a custody evaluation because you're not making any recommendations as to what's in the best interest of the child, because the decision to pay child support under the adult disabled child provisions, that is the child disabled and is paying the child support. And if you're going to pay child support, it's the child disabled and it's this in the child's best interest. Well, I tell the medical expert that's very experienced with special needs, you're not offering any opinion about what's in the child's best interest. You're only looking at what the disability is. And I hope that answers that question.
So we are out of time, clearly, and you guys can, again, visit our YouTube channel, Facebook. We do offer free consultations. For a range of price, there were some questions out there of your pricings. Reach out to Mike directly. You're going to get a copy of these slides, and he'll give you his prices. The last thing that I want to mention to you guys that is important, we've talked about the child support. We've talked about the first party special needs trust and some of these other important matters. One other important matter that I think is worth considering when you're kind of going down this highway is life insurance required for both mom and dad to fund the special needs trust in the future. And trying to get a court order for that is good, because if you don't, you're never going to have it. And so, for instance, let's just say that the child support you're signed up to get is $2,000 a month, and the payer dies and there is no life insurance, you're done. You don't get any of your, so it's really, really important to have those conversations. And I like to see the owner and the payer be, each other, so that way the other person can't cancel that, those policies. But those future care cost estimates are things that we can help you with. And that is something that is often ignored and not discussed in the divorce decree. So you got to bring it up. Guys, we're out of time. It's certainly been a pleasure. Thank you, Yesenia, for partnering with us today. Guys, reach out to Mike, reach out to our team. We're happy to schedule consultations, and we certainly look forward to partnering with you guys again in the future. Watch your email for today's slides as well as the recording. And thanks so much, Mike. Again, thanks for being with us.
Thank you. It was an honor to present, and thank you very much to Northeast ISD and to you as well, Allison.
Thank
Thank
you.
you. Take care.
Thank you.
Bye now.